Discussion. Senator Fielder.
Thank you, Mr. Chairman. I really respect and appreciate the sponsor's efforts that he put into this monumental undertaking. I know he's invested a lot of hours in it, as have I, but not near as many hours as he has. The Water Policy Interim Committee dealt with this legislation and analysis of the proposed compact throughout the 18-month interim. The Senate Natural Resources Committee last session dealt with the initial compact proposal, which failed to pass muster. At that time, we were assured it was a great deal and it was an eloquent solution, and it was forced upon us with this pass it or we're through talking type of a disposition from proponents. And I do appreciate the governor doing a limited reopening of the compact during the interim, but I don't think a lot of the main concerns were really well addressed. And I'm just going to speak to a couple of those now because I've asked a lot of questions and I've received a lot of answers. And here's what I've learned, that this compact allows a subset of Montana citizens to be exempt from Montana water law while others are not within the same geographical area. It allows some members of Montana to lease their water for up to 99 years. It allows others to lease their water for up to 25 years, both of those subsets being either tribal members or tribal government. But for non-tribal members inside owning private land inside the reservation, they don't have that ability to lease their water rights. So there's, I think there's inequality there that concerns me. Another issue for me, although some think it's a small issue, the independent analysis by the Bureau of Mines and Geology indicated that 30 to 40% of the people's wells in these different districts within the reservation were going to be adversely impacted. And although there were efforts made to put some mitigation monies towards that, there's no guarantee that those people's wells are going to be maintained and be able to provide water for them, because in some places it doesn't matter if you drill deeper. There's not a viable source of water down deeper in some of these places. The unitary management ordinance is a very big concern for me because it sets up a bureaucratic board, 5 people, and there's a high probability, at least at the onset, that board is going to be heavily influenced and mostly influenced by tribal members and not by the non-Indian people that live in the area. We were told by the attorney for the Compact Commission that the tribe, that's not necessarily so, because the tribe could possibly appoint people that don't have tribal interests. I don't believe that's a viable explanation. The tribe gets to appoint 2 people, the governor gets to appoint 2 people. There's no guarantee that those 4 people are going to represent the non-Indian members' interests on the reservation. That concerns a lot of people, including me and many of my constituents who live inside the boundaries of the Flathead Indian Reservation on private land. They are fearful of being placed under the jurisdiction of a tribally dominated administration, and they have good cause for that, and much of that good cause has been submitted for the record. With the way that people have not supported the compact have been treated by the tribal government. We've heard a lot of testimony on this. One of the most compelling pieces of information that I received was from the former judge, C.B. McNeil, a well-respected judge who has presided in that area of Montana for many, many years, and he was the author of Article 9, Section 3 of the Water Rights of the Montana Constitution. And he raised many, many concerns about the constitutionality and the complexity of this piece of legislation. And even though this legislation may be better than it was last session, and I think it probably is, I respect the efforts that have been made by all parties to make it better, it's still a highly complicated legal and technical issue. And it is far more complicated than any other piece of legislation that we have had to deal with since my time in the legislature, and I've been looking at this for a long time with the interim committee and the past session. And even Judge McNeil says that it's the Montana Water Court that has the expertise and is the appropriate forum for the determination of water rights. And I tend not to want to send much of our type of work off to the courts, but in this case I agree, the Water Court has the expertise. There's a piece of legislation in the House Bill 427, which would provide for the defense of water rights if the compact isn't passed and the tribe does levy 10,000 claims on Montanans' water rights throughout the state. There's a defense fund that would be set up by that legislation to help people defend their water rights, and also to allocate the proper funds to the Water Court to be able to handle the added adjudication responsibilities. So I think we do have a viable alternative to this, and I wish it hadn't come to this point where we have a take it or leave it document that we can't be comfortable with. I am not comfortable with it, and as much as I would like to have an agreement that I could support and that my constituents would feel good with, there's so much controversy with this and there's so much opposition to it. It's unlike any other compact we've ever seen in its scope and its controversy, and I cannot in good conscience support a piece of legislation when there's so little known about the long-term consequences of it. Thank you, Mr. Chairman.
That are better than the last compact. And much of my knowledge and my learning has been through the sponsor, and my understanding of this compact has been through the sponsor. But I do wish that I could be as in favor as him and as certain as him that there would be no unintended consequences. But I'm just not coming to that conclusion. Last night I was here. My study of this issue is still continuing. Last night I was here till just about 11:30. I got home at 11:30 because I was diving into more issues, coming up with my concerns and writing them down so I could verbalize them to the people of Montana. So what I'm going to do right now, I just wrote a statement last night, and I'm going to express some of my concerns. These are not an exhaustive list by any means, but just some things that I've discovered through my own questioning process and searches. So through my own questioning process of the legal experts supporting the compact, this is what I have discovered. I have discovered that the non-Indian landowners within the borders of the reservation currently use their water in accordance with those who have water rights in the state. Currently, lawfully, only water right holders are able to lease their water out to another individual. Non-Indian landowners within the reservation currently lease their water out, which seems to establish that the water usage is in fact a water right in accordance with law. In my questioning of legal counsel supporting the compact, it was made clear that the water rights of non-Indian landowners on the reservation are currently not tribal water rights, and they are not federal water rights. But after the passage of this compact, it will be firmly established that these water rights will become tribal water rights held in trust by the federal government, thus will become a federal water right. This was admitted by legal counsel and on the record. The compact establishes off-reservation water rights for the tribe. Proponents assure us that the federal government will not have rights over this off-reservation water. This claim to me looks to be false. The Federal Indian Trust Responsibility Doctrine is a legal obligation in which the United States towards Indian tribes has charged itself with moral obligations of the highest responsibility. According to the Bureau of Indian Affairs, the Federal Indian Trust Responsibility is also a legally enforceable fiduciary obligation on the part of the United States to protect tribal treaty rights, lands, and I emphasize assets and resources, as well as a duty to carry out the mandates of federal law with respect to American Indian and Alaska Native tribes and villages. Therefore, if off-reservation rights and co-ownership of Montana's rivers are granted to the tribe, This becomes an asset and a resource of the tribe. Therefore, the federal government has a fiduciary responsibility to protect, thus giving federal jurisdiction over off-reservation waters. There are areas of the compact that make specific reference to the Bureau of Indian Affairs having jurisdiction. I do not believe that it is in the best interest of this state to grant federal jurisdiction over the waters of Montana protected by Article 9 of the Montana's Constitution. Lastly, proponents threaten that if they do not get their way with every letter of this document, they will go after 10,000 other water rights all across the state, costing multi-millions in litigation fees. They use a section of the Hellgate Treaty, also known as the Stevens Treaty, to seize off-reservation waters across the state. The actual language of the Hellgate Treaty says the tribe has the right to hunt, fish, and gather off-reservation. But the key language here is that this right to fish off-reservation is granted in common with the citizens of the territory, which are non-Indian people. This Hellgate Treaty is also called the Stevens Treaty, and it was because it was negotiated by Governor Isaac Stevens. What we were never told by the pro-compact legal counsel is that there is actually two Stevens treaties affecting Montana. Both these treaties were negotiated the same year, 1855, and ratified by Congress. The Hellgate Treaty establishes the right for the tribe to exit the reservation to hunt, fish, and gather, while the Judith River Treaty actually establishes the rights of non-Indian people and the rights to settle the land and to utilize materials of every description for building, farming, navigating waters, etc. Proponents of the compact will argue that the Hellgate Treaty is the only one that establishes the reservation, so it is the only treaty that is valid. However, we are talking about off-reservation waters, and the Judith Treaty applies to off-reservation waters. Proponents have repeatedly threatened these intimidation tactics to promote this compact. What I care about is the truth, and I believe that if this legislation is truly the best for Montana, it will be promoted and pass on its own merits rather than threats. In my core, I firmly believe intimidation legislation is wrong. I also believe that legislation that needs to be passed by intimidation also contains dangerous consequences. I cannot and will not agree with this practice. I also will not support a Nancy Pelosi-styled passage of legislation where we just pass it and find out what it does later. I have spent more time studying this compact issue than any other legislation this session, and I am still far from having been able to sort through the mountain of public comments, let alone the extensive technical and legal documentation that surrounds this issue. If this was a good compact, it would have a much broader public support. Every other compact that has come before this legislature has been passed by 80 to 100% support. I ask the other senators in the room, have you thoroughly investigated this document? Are you absolutely sure of the intended and unintended consequences? We are told that we are not even allowed to amend this document now, and upon the passage, it will surely never be changed. If you don't fully understand every aspect of this permanent and binding intergovernmental compact, then I would encourage you to join me in voting no. Thank you.
Further discussion? Further discussion? Senator Vincent. We're not ready. I'm going to speak last.
Okay. Well, Mr. Chairman, I'd love the opportunity to respond to any comments you have if you had any questions, but I don't think it's a question you're going to be asking. Thank you, Senator Fielder and Senator Hinkle, for raising some issues that I was wondering if I was going to talk about it, and I'm going to specifically address some of your concerns that you just mentioned, and I'm also going to ask you a few questions if you would yield to those questions. First of all, non-tribal members can lease their water as many years as they would like on reservation. Your second point about the wells and the fact that we're going to have some groundwater wells that may be impacted by a change of water use. I would hope that everybody on the Water Policy Interim Committee who has spent the time studying the Water Use Act and what happens when anybody is changing their water use would recognize the fact that inside of this compact, we are actually establishing a precedent that no one else in the state has. If you want to change your water use from flood irrigation to center pivot right now, anywhere in the state, and that change of use impacts a neighbor's well, that is the right of that water user to do so without having to go drill their well deeper. One of the things that we did in this compact was set up a fund to help alleviate those concerns. But I would tell you that my worry in doing that was going to be from the agricultural community and the fact that they may not like that precedent because maybe someone would want to have that application everywhere else in the state. As far as the UMB, we also had that discussion on the Water Policy Interim Committee, and I decided that it was going to be better to have local control and made that motion, and the majority unanimously agreed that we needed to have more local input into that decision of who was going to sit on that board. So we have county commissioners that are now nominating those that could serve on it to the governor, to which he chooses from. So the individuals that are inside that area are having more local say into who that is. You know what? That doesn't. Perhaps the local county commissioners would want a Native American to serve on that board if they thought he was qualified and he'd do the best job. I don't think that that's something to be concerned about. But I do know if the people that elected those individuals have a problem with that, they can remedy it. As far as the dual management approach, it's something that I talked about a lot. It's something that I thought we needed to do in this, but I wanted to remind you and everybody else that in the other compacts where a dual management approach has been implemented, you have two different management, hence the term dual management, but those basins are traditionally closed. And if you want access to extra water, you have to go buy it from the tribes. We have avoided that with the unitary management approach in this bill. Some of the comments that you made, Senator Fielder, about CB McNeil, I also responded to the email because I received the email, and I believe you received my response to the email to CB McNeil, but I'm curious as to what part of his analysis you thought was most relevant to this discussion, because his analysis was fundamentally flawed, and while I had a great honor in corresponding with somebody who sat on the Constitution, or was a part of the Constitutional Convention, he was not the single author of that provision in the Constitution. There was others that worked on that besides C.B. McNeil. I'm not sure what part of that you would like to clarify for me so I could answer your question a little better, but I would love to know what it is exactly that in his correspondence with me and you, what was it that you felt needed to be responded to that hadn't been as of this point?
Mr. Chairman, I thank you. I'd be glad to respond to some of that. As far as the leasing of water, these are my notes from the hearing, and my questions were regarding the leasing. And my notes say that the tribe can lease water for up to their water right for up to 99 years. Other tribal members, individual tribal members, can lease for 25 years, and non-tribal members cannot lease for any years. That was from the hearing. Those are my notes from the hearing right here. As far as the attempt to resolve the wells that are going to be adversely impacted, the right of an individual water user changing use is different than a government act mandating a change in use that's going to cause people's wells to dry up. County commissioner involvement was a nice gesture towards trying to make it appear that this UMO board won't be dominated by the tribe. But the tribal government has engaged in political elections with government funds in the tens of thousands of dollars to influence elections in this state to get this compact passed. We know they did it last year. They testified on the record that they had done this. And I don't think it's wise policy to set up a system that's going to invite more tribal government involvement in influencing the outcome of the elections and their county commissioners so that this UMO can be stacked with representation of the tribe. And I fear that will happen because the tribe has an awful lot of money and they're going to have an awful lot more if this compact is passed. And having put that money into elections, and no other government entity in this state can put money into elections, that concerns me a lot. My county commissioners in 3 out of the 4 counties I represent in northwest Montana are on the record as being opposed to this compact, even with the changes in provisions. One of the primary reasons is because the irrigators, the Joint Board of Control irrigators, are not satisfied that their water rights are protected. But that's not the only reason. 3 out of 4 of the counties that I represent in northwest Montana, 2 of them, which contain significant portions of the reservation, are opposed to this compact. There's still problems that need to be worked out. Now, they're not saying don't pass a compact. They're saying there's still problems that need to be worked out, and we're not there yet. We are not there yet. I'm sorry, Chairman and Senator Vincent. We're not there yet. It's not ready.
Senator Field, the question was, what in C.B. McNeil's correspondence did you have a problem with?
Mr. Chairman, Senator Vincent, as far as C.B. McNeil's correspondence, I did not see your response to it. I received his...
What part of his correspondence with me did you, Mr. Chairman, Senator Fielder, what part of his correspondence do you feel I have not adequately addressed, and what do you believe needs to be adequately addressed?
Well, Mr. Chairman, Senator Fielder, I think the main point of C.B. McNeil's, Judge McNeil's correspondence is that the Montana Water Court has the expertise to deal with adjudication of water law. This legislature doesn't.
Okay, and I was wondering if that was what you were going to speak to, so thank you for answering the question. And I guess where I believe that Mr. McNeil made one of the fundamental flaws in his correspondence was the fact that we were not... that we were going to have a much better outcome by adjudicating. And you served on the committee. You know what prima facie means, right?
I think so, Mr. Chairman. It's been discussed, but I'm not a lawyer.
Well, and neither am I, Mr. Chairman. But what I'm saying is, the things that are fundamental in the Montana Water Use Act and the things that are fundamental in trying to make an educated decision on what will happen should these claims get filed, it is essential that somebody understands the basic premise of what a prima facie claim is. Okay? And what we're talking about is these claims getting filed, and over 30 basins, 35 basins, perhaps 40 basins are going to need to be reopened. Many of these basins are already been adjudicated, and these claims will have prima facie standings. Those objectors will not have the same luxury of using the same metrics to object to those claims, because things like in-stream flow, lack of point of diversion, lack of putting it to a beneficial use, do not apply. That's why in your packet you got the COIL letter that I expected everybody to read, because she's very clear as a former water master of the court in explaining what that means. And when somebody says, I would rather adjudicate, or that's where this process belongs, is in adjudication, you know what? I disagree that it is in the best interest of Montana for everybody to re-adjudicate from the Idaho border clear to Townsend. I do agree that those that are on the reservation that have not had their claims adjudicated yet should have the ability to do so. That's why this compact allows it. Why should we require everybody else to go re-adjudicate? One of the provisions in this compact that is a significant change from 2013 is just that. They can. And in fact, they can also get the benefit of a delivery right and adjudicate at the same time. They can have their cake and eat it too. As far as the take it or leave it, you know what? The Montana legislature created the Compact Commission in 1979 because we decided as a body back then that we did not want to adjudicate. We did not want to litigate. We wanted to settle. And the Compact Commission has brought every negotiated settlement back to us in the same way that this was. That was the charge of the legislature. And we would give it an up or down vote. And that's what we're doing here. And Senator Larson, Kerr Dam has absolutely nothing to do with this compact. Thank you for your support, but it has absolutely nothing to do with this compact. Senator Hinkle, and I went through some of the points that you made. You know, a lot of this is, you know, your comment about the Stevens Treaty in Article 3, and I want you to continue your research, because when you start, and I want you to read the packet, because most of the concerns that you expressed in your press release was answered. And I don't want to belabor the points and go all through it again, but I thought that we had already had that conversation. But you know, things like these rights are in common. The Supreme Court has dismissed that 6 times in 6 different ways and won't even give it certiorari should you try to litigate it again. Those are important facts when trying to make a determination of whether this is a fair and equitable settlement. And it is the responsibility of every legislator to do their best that they can to get themselves educated. That's why I tried to put this packet together for everybody so that they wouldn't have to spend the 500 hours trying to read all of the case law and make heads or tails of it like I did. I boiled it down. And I want to continue the discussion. I know you are honestly trying to educate yourself, and I honestly respect that, and I want to help facilitate that so that you can make an educated decision. As far as intimidation, I don't know, and believe me, that was part of my problem with the previous compact too. I felt that was the only real talking point that was really used. But it's really tough to talk about what will happen should we not settle without speaking to the truths. And it's those prima facie claims. It's the people that if they're incorporated, they have to hire a lawyer. They can't even represent themselves. The people that have spent $200,000 already adjudicating their rights, they're going to be forced to go in and do it again. When we've allowed the people that have not the ability to go adjudicate them. And I'll tell you what, even if they're successful, the Ninth Circuit Court has already said that these rights on reservation are time immemorial. They're going to have a junior right. In this compact, the reason that we made them tribal rights is so that they would all have an 1855 right, so that no one can get called. And if you study the Water Use Act a little more, you'll understand the Greek I just spoke to you. Members of the committee, there are a lot of conversations that we need to continue to have. The misinformation from people who know better that has been disseminated on this issue is incredible to me. I know that there's it's the reason that we have such uncertainty out there among the people who are trying to understand it as well. I know what they feel like because I was on that journey 2 years ago, 3 years ago, and it's a long one. But you have to put your faith in the facts, and you have to commit yourself to finding them in order to make an educated decision on this. I want to help facilitate that as much as I can to anybody that's willing. But until then, Mr. Chairman, members of the committee, we need to move this forward and continue to have that discussion. Mr. Chairman.
Thank you, Senator Vincent. Is anyone else that would like to comment on this before I speak, and then we take the vote? Senator Fielder.
I would, Mr. Chairman, since there were some things brought up that I didn't bring up, but I think they were directed at me. Number one, interpreting the facts differently than somebody else is not misinformation. It's interpreting the facts differently. There are people who are interpreting the facts differently than Senator Vincent, who has admittedly spent 500 hours studying it, who has an extensive background, both legislatively and professionally, in these types of issues. The 10,000 claims that have been threatened, if the compact doesn't pass. I keep thinking about the Nez Perce and the Idaho. You know, Idaho was in the same situation a few years ago, and they were being threatened too, that they were going to have thousands of claims filed if they didn't agree to a compact. And Idaho didn't agree to a compact, and those claims did go to adjudication. They did reach a settlement. But it turned out of the 6,000 or 7,000, I think it was nearly 7,000 claims filed there, only 7 were proved valid. And a large purpose for them being proved valid was because that treaty with the Nez Perce identified off-reservation fountains and springs. This Hellgate Treaty does not identify off-reservation waters and reserve those waters. And actually, the Nez Perce Treaty did specifically reserve off-reservation waters. They had a reserved right to off-reservation waters. This tribe doesn't have that. This treaty doesn't have it. I understand it's been a negotiated process, and so that's been offered up as a point of compromise, but I don't agree with providing off-reservation water rights on a federal reserved water rights settlement. The water rights are supposed to apply to the federal reservation. The federal reservation is the Indian reservation, not the rest of Montana. Now, Mr. Chairman, Senator Vincent mentioned that the people can still adjudicate, and he built that language into the compact, that the people who want to adjudicate can still adjudicate, but they'll never win because the tribe's given time immemorial water rights in this thing. And there's also a provision for mutual defense where the federal government, the state government, and the tribal government have to work against anybody that would contest any aspect of this compact. So a citizen of Montana is going to be at a huge disadvantage. Senator Larson mentioned his deep understanding and deep study of the issue, and Senator Vincent just corrected him and let him know that Care Dam and what he thought was part of this compact doesn't have anything to do with it. That's a perfect example of how difficult it has been for the legislators here to grasp this issue, to understand the full magnitude of it. And that's I appreciate Senator Larson taking time to study, but for the sponsor to say you're dead wrong, even though he supports it, is an example of what's wrong with this compact. Very few people understand it. Very few legislators have read all the information. Very few legislators have digested it and understand it. So I do appreciate the sponsor's passion and his commitment and his effort and his work. But you've reached a comfort level that most of the rest of us haven't been able to reach. And to ask us to vote yes for a permanent, binding, intergovernmental compact that cannot be changed in the future by any one party, it cannot come back to this legislature for a fix like any other piece of legislation we pass. I think it's wrong to ask us to support something when we don't fully understand it nor fully appreciate it yet. It's a tough issue, and there's still a lot of gray area, and to ask us to vote yes when we're still studying it, I just don't think that's responsible.
Mr. Chairman, if I can rebut to your last point first. Asking an elected official to make a decision in an important policy matter is in fact why we all put our $15 down. That is our responsibility, and while I'm sorry that you feel that it is not fair, that is what we're here to do. Anyone that is making a video and shipping it out on YouTube claiming that time immemorial rights are Indian folklore and legal fiction, it is repeated more than a dozen times at a podium, that's misinformation. And I'll call it for what it is. As far as the adjudication, Senator Fielder, I'll have you go back to our Water Policy Interim Committee report and read what's in it. Read our legal analysis. You just contributed to the misinformation by saying that there was only 7 claims that the tribes got out of that settlement. 200 off-reservation in-stream flows. 200 is what they got. An entire fishery that the Idaho had built and developed was given to them. Tens of millions of dollars and tens of thousands of federal lands. That was the settlement. I encourage you to read Adair. I encourage you to read Winans. I encourage you to read Naaman. I encourage you to read all of the case law that is central to this negotiation before you make claims that there is no valid reason to even consider something like off-reservation rights. If you had, you would understand that you can't make those kinds of statements. Adjudication is, as far as the mutual defense clause, I mean, adjudication under the McCarran Amendment is done in state courts. This compact allows that to happen, adjudication. There's going to be nobody arguing against the co-ownership claims, besides maybe the tribe. The state's going to be sitting across the table looking for an abandonment ability as these individuals are objecting and trying to prove up their historic consumptive use in water court. The Attorney General is going to be sitting over there hoping that, not hoping probably, but DNRC probably will be looking for an abandonment that they can claim, because it's our water, it's the people's water, and if you haven't put it to a beneficial use, it belongs back to the people. That's the way the Water Use Act works. We should all read it. And lastly, I'll say, you know, there's two things that are dangerous to this discussion. And it's something that I've been trying to work on, and I continue to work on it. And it's either blind faith or blind opposition. Neither allow for an atmosphere for enlightened decision-making to happen. There is no question that is stupid. There is no question that is silly. But let's discuss the facts, and let's discuss the substance. Mr. Chairman.
Further discussion. Senate Bill 262. Anybody would like to make? Senator Hinkle.
Mr. Chair, Senator Vincent, I reject your belittling of me because of the conclusions I have come through because of my studies. And I want to remind you, a lot of the conclusions that I've come through have been through my own questioning process that are on record, both at the informational seminar and at the hearing. And you did say, you know, we paid our $15 to make a decision, and that's our job, and we're doing that. But you need to respect, if we're not comfortable with this legislation, that we're going to vote no.
Further discussion. Senator Vincent.
Mr. Chairman, members of the committee, Senator Hinkle, it is always your right to vote no. And my apologies if you consider that belittling. I took some of your press release statement that you read as an affront. So we're even.
Further discussion. Seeing none, I just would like to make a statement. Nothing I'm going to say here needs to be rebutted by the sponsor of the bill, in my opinion, and I have no plans to speak about the bill on the floor, so here's my opportunity to explain to my constituents and people of Montana why I can't support the bill. I've been here in this age of term limits, a fair amount of time, and unfortunately, as a student of the legislature, I've witnessed prior to coming and since I've been here that typically in my opinion, the worst pieces of legislation that have been passed are complicated and they're brought to the legislature not in the most timely fashion that gives us the best opportunity to make a decision of this magnitude. This bill, I think, is without a doubt the most important piece of legislation I've had the opportunity to vote on. And I don't shriek and never have from an opportunity to vote no or yes. But I try to make the most informed decision I can, and what I base those decisions on, I like to think, when I first came here, was I called it the 4 C's. I was going to look at whether the bills we looked at were constitutional, and I could vote for it if it passed constitutional muster in my mind, whether or not my conscience would let me vote for it, so I could look in the mirror the next day and decide whether or not I made the right decision in my mind, whether it was good for my constituents, and lastly, whether it was good for my caucus. And in order to make that decision, I have to, being a simple person, and I know that Senator Vincent has forgot more about this compact than I know, and I freely admit that. But I have to look at the original intent just like I do at the Constitution. And when I look at the original intent, I have to go back to the original treaties that were signed by the people, what they had in mind at the time, not what's going to be financially beneficial to the tribe at this point, but what they were thinking at the time that they signed the treaty. Words mean something. And so the original intent, I read that they clearly gave up their rights off reservation. And it's clear to me that, in my mind, that there's no way they could have thought about, in-stream flows and all the complicated issues that exist today in the environment that we live in. So I can't support something. And I know that Senator Vincent would rebut me right now, and he would say that, well, the courts have ruled on much of this. But the courts aren't infallible. Courts have made horrible decisions in the past. And I'll just bring a couple of them. And I know that, in my opinion, one of the worst decisions, Roe v. Wade. Now, I know that's going to really divide people here, but the reason why I don't like that decision is because there was no prior court precedent, and it gave that they came up with this concept of privacy out of thin air that didn't exist in prior court rulings. Another one was Gideon, that basically said that everybody was entitled to an attorney at taxpayer expense. That was another court ruling, I think, that's gotten us in some trouble. And I might refer to just the fact that we've, and it's bared witness that the state assumption of the public defender's office hasn't been a good thing. It's going to bankrupt the state, or it's a continuous growing burden financially on the state. That decision had no prior court precedent other than the one for capital punishment in the 30s. And so it was completely out of thin air. And probably the worst decision of all time was Dred Scott, that basically said that black people aren't equivalent or equal to white people. So the courts aren't infallible. They make decisions, bad decisions, continuously. And I might even bring one up that is really recent, is I think the decision to strike down our one man, one woman in our marriage amendment to our Montana Constitution that was approved overwhelmingly by the people of Montana. And one judge says, no, that's unconstitutional. So I think it's incumbent upon me, and should be incumbent upon everybody else, to look at the original intent, because that's really all we have. And I think, in my mind, it's a real stretch to think that these off-reservation water rights exist. And I can't support it. This is probably the worst political vote I'll ever make in my life. Because the right thing for me politically, and my irrigators and the people in my district, which is North Gallatin County, which is the majority of the irrigators in Gallatin County, all the irrigators in Broadwater County, and the vast majority of probably the irrigation in Lewis and Clark counties right out there, and now these people are my new constituents. But my conscience won't let me support this bill for the above stated reasons. And with that, question's been called. We'll take a roll call vote.
The motion is due pass for Senate Bill 262. Senator Vincent? Yes. Vice Chair Fielder?
No.
Senator Sands?
Yes.
Senator Larson?
Yes.
Senator Driscoll?
Yes.
Senator McNally?
Yes.
Senator Moe?
Yes.
Senator Hansen by proxy?
No by proxy.
Senator Hinkle?
No.
Senator Carey?
Yes.
Senator Swandle?
Yes.
Chairman Sales? No. Motion passes 8-4.